Question 2 on the July 2022 California bar exam. You really had to keep a tight rein on your timing because the first question on this exam was a UCC contracts with two different contracts. It was issue-packed and quite a racehorse. Then you got to this one and you see two calls. First call, what arguments can Paloma make in support of her First and 14th Amendment claims? Discuss. First Amendment, arguments in support of a First Amendment claim. That means I don't need to talk about standing. She's already raised the claim and they're only asking about arguments in support of that claim or those claims. Then call 2, will either or both of district's arguments in support of its motion to dismiss Paloma's lawsuit be successful? Arguments in support of a motion to dismiss. All right, then they have to tell me about the motion, probably in the paragraph before these calls. So I'm going to look at that and see what the grounds are. So far, all I've seen is constitutional law. So that paragraph says, district has moved to dismiss Paloma's lawsuit as moot on 2 grounds. Okay, so the issue is mootness. I've got a pure constitutional law hypothetical here. Moot on 2 grounds. Now, I need to put this all in context for myself. I need the relevant law front and center in my active memory. And it's a relatively brief law that I need to worry about. Let's take a look at mootness. What I would have memorized for mootness for the bar exam would be a general rule, and then I would need to know the 4 exceptions to mootness. I would probably want to tell the grader all of those as background law, but only 2 of them are being raised here. There are the 4. That's what I would have memorized. And so, is it capable of repetition yet evading review? Voluntary cessation by the defendant, but they can resume at any time. Class action, I don't see that here. Collateral matters remain to be decided. I don't think I see that here either so far. Back to the hypothetical. What are the 2 grounds for mootness that district raises? First, because she's no longer a high school student. That's pushing me to capable of repetition yet evading review. And B, district has now redefined gang-related activities in its rule in a manner consistent with State X's criminal code. That one has to be going toward cessation of whatever they were doing that she's objecting to. But they could start again if they were to change that rule again. So I think those are the 2 relevant exceptions to mootness that I'm going to need to analyze. Capable of repetition, yet evading review. And of course that's here. That's a favorite one for bar examiners, for law professors too, because someone who's poorly prepared, who's not thinking about that one, would think that it applies if anybody could be harmed by this rule. Anybody could be subject to it and have a case. And that's not the case here. Capable of repetition by these parties. In other words, the plaintiff in this one, Paloma, has to still be subject to the rule and could be harmed by it. And that's the key to this exception to mootness. So they're going to give me facts that tell me whether she's still subject to this rule or not. That'll be the key. And then the B part, redefining gang-related activities, yeah, that means that the defendant has voluntarily ceased what they were doing that harmed her or that she claims harmed her, but they could resume at any time. That's what I'll need to analyze for that B part. That's all that I'm going to have to cover in Call 2. That's not such a huge amount of law. And notice how simple it would be to have a final outline that had the rule and the 4 exceptions. And then you just need to know how to apply each one of those 4 exceptions in case you were to get anything that involved mootness in a hypothetical on the bar exam. So what do we have under the First Amendment? Well, we have public school district in state X is attempting to reduce gang violence in district's high schools. After consulting with local law enforcement, district has determined that most violence results from confrontations between 2 groups, the West Siders and the East Siders. As a result, district has adopted the following rule for all high school students. No student shall wear any label, insignia, words, colors, signs, or symbols that reflect gang-related activities. Students violating the policy will be immediately suspended or expelled from school. Well, this is First Amendment. They've given us the government's interest, reducing gang violence, and we have a First Amendment problem here. Literal wording from the rule. What we need in our minds is First Amendment. So, what does your final outline look like for First Amendment? And this is speech. We put our entire speech summary on one page, our analysis strategy for speech. And I will put a link in the description below so that you can get at that one-page PDF. First, you set it up with a general rule, and then you analyze that there's state action, of course, but then you start with facial attacks, unless they tell you not to. But here, it's a wide open call. So I need to think about whether we have a prior restraint, overbreadth, vagueness, unfettered discretion. It's very likely that we have more than one facial attack. A weaker answer will see the most obvious one, and that's it. And it's a natural tendency that once you've seen one, you don't think about the others. That's why realizing that there are 4 ways to do a facial attack will help you mentally run down the list and make sure you cover every one that's relevant. So let's go back to the facts and look at that rule. The rule says no student shall wear any label, insignia, words, colors. All of that sounds void for vagueness. How do you know what's going to violate that rule? What are the other reasons that we can facially attack? Well, how about prior restraint? They're basically saying you can't speak by wearing any label, insignia, words, colors, signs, and so on, or you'll be punished. So they're telling you before you arrive with any of that on that you can't do it. That's a form of expression. I think prior restraint works here. Go on. For several years, Paloma, a high school senior, has had a small tattoo of a dove on one wrist. A tattoo of a dove. her self-expression as a peaceful person. So if you haven't figured out that it's speech yet, that should tell you that this is First Amendment speech claims. Paloma has never been associated with any gang, including the West Siders and the East Siders. After learning of Paloma's tattoo, district officials described it to local law enforcement officials, who said that it sounded like a West Sider gang symbol, which includes birds. In other words, you can't wear anything that has a bird on it to school. Well, doesn't that mean that it's overly broad? Paloma was suspended for the last 10 days of school after she refused district's request that she either wear long sleeves to cover her tattoo or have it removed. Okay, so far I've seen among the facial attacks, void for vagueness, that it's a prior restraint, that it's overly broad. But isn't this paragraph also telling me that there's unfettered discretion here? I don't see any articulable standards on which these district officials are going to make this decision. So I think that we can also raise a claim of unfettered discretion here for Paloma. I think that whoever wrote this hypothetical wrote it so that you could raise every single facial attack. Okay, that's pretty clever. As I said, a weaker answer will see one or two, but not all four. If you know there are four, it triggers that recollection of what the four are, and then you look to those facts to see if you can analyze every one of them. Paloma, now graduated and attending the college of her choice, has brought a declaratory relief action challenging the validity of district's policy under the First and 14th Amendments to the United States Constitution. We'll come back to that. Paloma, now graduated. But meanwhile, go back to your outline, our final outline, our analysis strategy for speech. After you've thought about the facial attacks, think about laws that regulate conduct. I think that this could be analyzed as a law that regulates conduct. The conduct being walking into school with a dove tattoo on your hand. What about time, place, and manner restrictions? The government would love to convince the court that this is merely a time, place, and manner restriction. This one clearly isn't because it's content related, but still tell the grader that, analyze it. This is a content restriction. So what do we do with content restrictions? Well, that's a strict scrutiny analysis. And if you think about this one, that district is going to fail a strict scrutiny analysis. So what do they want to say? They want to say, but, Your Honor, this is low value speech. What we're really trying to do is regulate based on incitement, so that there's a 3-element test. And there it is. Look at that strategy. You go down through facial attacks, you think about whether there's conduct that communicates, you think about whether the government can get the court to use rational basis because it's merely time, place, and manner, and then if it's content-based, you also think about whether the government might claim that it's low-value speech. And I think we have it all in this hypothetical. I think you could raise every single one of those claims in this hypothetical. So let's go back to mootness, to call 2. We had said that we had capable of repetition yet evading review, and that there would be facts that would let us know whether that would work. Well, the facts are right there. Paloma now graduated and attending the college of her choice. The district is right that it would be moot insofar as that exception to mootness doesn't work. She's graduated. She's not subject to this rule anymore, and she would have to be subject to it again for that exception to work. So I think on their A grounds for mootness, they prevail. What about the B grounds? They have now redefined gang-related activities. That one might work. Analyze that. And then go through and on call 1, follow our analysis strategy and analyze every single part of it. So look at how clever whoever wrote this hypothetical was, aside from the cleverness of the name Paloma with her dove tattoo. Whoever wrote this gave you the opportunity to analyze every single facet of our schema on speech. Now, as I said, I will share with you in the description below a link to get to that one-page handout. And the way you get there is to follow the link that says for power law. Just open that link and scroll down on the page and you'll see samples of our schemas. And there's one there that says constitutional law speech. Grab that handout. And of course, please join me for the rest of the debriefs.